case of cyber offenses, who falls prey? This is my question. Who falls prey mostly? Uh, is it to continue gender neutral throughout, or is there any need for a gender friendliness felt? This is a point of deliberation right now for the time being. I think many of the audiences are a great many have been familiar with the concept of cyber offenses. Well, I will be into cyber offenses for some time, and then I will focus on how gender friendliness is invited to the present scenario, so that our concept of justice be furthered. This is the issue. Well, so laws vis-a-vis gender. How come cyber laws come face to face with the concepts of gender? If is there any need for a reform based on gender as far as cyber laws are concerned, especially cyber offenses? Cyber laws, of course, there is. Well, we can directly have it into two segments. Well, naturally, one should be civil law and the other should be criminal laws. Civil laws, we will, when we are considering the civil laws, what we understand that it is almost gender neutral, and it is like that. It has to be like that. In civil laws, almost it doesn't make any difference if the victim is a is a woman, then definitely she may need some help from the side of from the it may be suppose if she is hailing from villages and she is illiterate, there is chance for going into the percentage of illiteracy that is prevailing in India. It is mostly women. Therefore, women as such as a class have some sort of backwardness, and therefore it has to be neutral. It cannot be gender neutral always, but it is almost gender neutral. This is a scenario prevailing. And when going into criminal law, we need to put some idea into it. We need to put some idea into it because when considering criminal law, if a criminal offense is being committed to a man, same consequences are not expected if the same offense is committed towards a woman. The consequences will be high. Why? See, you are all living in India, and therefore you have to be somewhat gender specific, especially in criminal legislations and all that, criminal law legislations and all that. Well, what is the concept of gender-based violence? Is there a concept called a gender-based violence? There is, because even the UN states that you may just see the General Recommendation 19 in the UN Office of the High Commissioner of Human Rights, Committee on Elimination of Discrimination Against Women, 1992, and that describes what gender-based violence is like. Well, violence that is directed against a woman because she is a woman. Simply because she happens to be a woman, she is made to suffer a specific violence, which is the most aggrieved violence which is being faced by the woman because she is a woman. It's rape. You can understand it. See, when rape is alleged, it can never be alleged against a man. With a man as a victim. No, it's not physically impossible. So therefore, there are offenses which are directed against a woman, which is the offenses happen due to the fact that she is a woman. So in such cases, this is called a gender-based violence. Or that same offense may be there, but this particular offense will be affecting the woman disproportionately. Men are rather saved, not women. There are certain cases example, for example, if a murder is being committed to a man, and the same murder is being committed to his young wife also, so the consequences that ensues out of these two murders will be different because as a woman passes away her suckling child, what will he do? So therefore, there is a lot of differences between that particular offense affects women disproportionately. This is different. For example, disrobing a particular man and woman. You are disrobing a man, it doesn't matter much. But when you are disrobing a woman, the consequences are high. This is it. And includes physical, sexual, or even emotional or psychological harm committed both offline and online. So, this is the difference that comes right now. What is psychological harm? Well, psychological harms are there, which you can always uh, have a concept of. Secondly, it can be committed both offline as well as online. So now it comes. Now it comes. When it comes to the cyber offenses, it should obviously be in the online. Now coming to the Indian scenario, what we see in the Information Technology Act, we see offenses, cyber offenses, particularly mentioned in the Information Technology Acts. Cyber offenses are there. I've picked up some of the offenses, not all offenses. 66D, first. 66D is punishment for cheating by personation using computer resources. And using computer resources, if 10 persons are being cheated, we all know that almost 7 is a woman, is directed against or directed against women. But still, this section continues to be gender neutral. That is it. There has been umpteen instances of cheating by impersonation in social media. You can see that. Some person who will appear in the social media and Instagram account makes a advance towards a young girl. Probably she may be carried away by his profile or things develop like that. And there may be sexual exploitation. There may be exploitation of money. Many exploitation processes will be over and off late. This girl will be ransacked. So such instances do happen quite a lot, quite more. This happens. I think it's not. You may be feeling like this. No, why should women alone be focused? It's not like that. The problem is that whether you are amenable for that or not, it's not the issue. You are all studying in a professional college. You may be somewhat more oriented, but there are a lot of women who are not that oriented as you used to be. So therefore, personal reflections men do not have much role to play in this aspect. Secondly, the survivor, there is with respect to the effect of these things, the survivor is left to public or media trial and disgrace. It happens. I know if some woman is being cheated in the cyberspace, and if she is able to share her experience in the cyber media, there you know what sort of bullying will be happening after that. Now, secondly, it doesn't make any difference based on gender status. This is a basic issue. So even if it is being directed against a woman in a disproportionate way, the statute remains to be gender neutral. So this is a point I wanted to look at. Now coming to section 66E, that is punishment for violation of privacy. There you see it. Uh, there you may see it. So violation of privacy, you can always see that when a violation of privacy occurs for a woman as well as a man, the consequence that happens for a man will be somewhat lesser. So disproportionate consequence rate is there in favor of the woman. Still, it is gender neutral. This is the issue. The section says like this: intentionally or knowingly captures or publishes or transmits image of a private area of any person without his or her consent. His or her consent. Both are there. Violating the privacy of that person. And private area has been mentioned as it is undergarment clad genitals, pubic area, buttocks, or female breast. Uh, when it comes to the definition of private area, this is somewhat gender oriented because female breast is included there. A man's breast is not coming within the purview of this particular section. It's not a private area. It's a private area if that is a woman's. But my suggestion is that because a normal legislator, a normal legislation standard should be that the consequences that ensues for a victim of the weaker of the fairer sex is higher, and therefore punishment should be higher. It doesn't happen here. This is my point. Now you may see section 67 and 67 capital A. It is publishing or transmitting of material contains sexually explicit acts. 66(7) capital A, we will go further. Now, publishes or transmit or causes to be published or transmit obscene material. Section 67 says about obscene materials alone. And 67A says what? 67A says uh, sexually explicit act. What is a sexually explicit act? Any material which contains a sexually explicit act or contact. So the act should be sexually explicit. So there is a difference between being obscene and being sexually explicit, and that difference, of course, that is within the meaning of all. 67, the section 67, it's mentioned about obscene materials, and now obscene material, what it's more made more specific, sexually explicit act or contact. So it may happen in a very close relation that there will be sending of images or rather videos which contains some sort of a sexually explicit act between lovers, and it may so happen that these persons may fall apart because if a lady, a girl does have a right to, and a boy also does have a right to retract at any point of time. Democracy needs that that right be honored at any point of time. It doesn't happen. Instead, these boys, mostly boys, what they do is that they go to publish it so as to harm the reputation of that lady. So the question is that the privacy is being infringed. Your valuable right of privacy is being infringed. Therefore, 67A. Even if, again, even if the consequences are different, the section is gender neutral, and it does not prescribe any enhanced punishment for an offense that is committed against a woman. This is the point. Now, IT Act Section 67 capital B, it's punishment for publishing or transmitting materials depicting children in sexually explicit act, etc. So again, children. Why children are made a separate category? Children are made a separate category simply for the reason that they are a vulnerable section. They are a vulnerable section, and our lawmakers are not to the tune of understanding or rather assimilating for themselves that women do form a separate category in themselves, which need attention of lawmakers. If children are capable of getting that sort of an attention, then obviously women should also be. This is a concept which I just want to imbibe by. Now, publishes or transmits or causes to be published or transmitted what? Any material which contains children in sexually explicit act, or even browsing or downloading, that is also made of offense. If you are browsing for such a video in some prohibited site using some very vulnerable browsers, some very red letter browsers, even then you are committing an offense. So this should be there for even the rigor may be different, but still that should be there. Under section 67B, it is even more for aggravated form of offense, bringing within the obscene material relating to children with further enhanced punishment. So when it comes to section 65B, you will see that punishment is being enhanced. I'm not into the quantum of punishment for all these offenses, but basically the concept is that punishment goes high. Consequences as to bailable offense or non-bailable offense, that also goes high. But at the same time, the standard that is required for treating an offense against a woman is not recognized at all. This is the point. Well, what happens in the cyber world? Simply because you happen to be a woman, there are many, you are subjected to many offenses, many such offenses. The concepts have been crystallized some 10 years only only for the last 10 years, and not more than that. This concept is not old up. This is a very recent one. See, simply because you happen to be a woman and you happen to be there in the cyber world, your consequences are higher. Your vulnerability is higher. So there are such offenses. Which are they? We will see. Therefore, it is there. Therefore, we have a concept like violence against women and girls in cyberspace. In the cyberspace. So therefore, the concept is cyber VAWG, WAG. Cyber WAG. What is a cyber WAG? So there is violence against women and girls in the cyberspace. So what are those offenses like? Well, the point of attraction is a woman, and she is there in the web. What happens? Firstly, it is cyber stacking. What is cyber stacking? Stacking is an attempt to contact such a woman or foster personal interaction repeatedly, despite a clear indication from the woman that she is not interested. See, I am after a woman, and that woman has given me very strong indication that she doesn't want to have an affair with me. Still, I am repeatedly behind her. This doesn't happen to a man, and even if it happens to a man, it is only very minimal. It's only very minimal, and the consequences are lesser also. As far as women are concerned, the infringing of privacy is of higher consequence. You agree it or not, this happens. Now, the next is doxing. What is doxing? Doxing is search for and publishing private or identifying information about a particular individual or a particular organization in the internet, typically with a malicious intent and content. There is malicious intent and content, and you will be publishing somewhat private informations about you in the internet. So this is doxing. Doxing is also mostly practiced against whom? It is practiced against the woman, especially those women who are in cyberspace. Well, there is a concept of cyberbullying, and the concept of cyberbullying must be known to you. It's the use of electronic communication to bully a person, typically by sending messages of an intimidating character or somewhat threatening in nature. So you are sending threatening or messages to somebody, and mostly that will be directed against a woman also. So this happens, and then what? There is hate speech. Hate speech. This is the era of hate speech. Whenever you open any social media page, you will see that hate speech is being done by somebody, and there will be a lot of viewership for such hate speech also. So hate speeches are mostly directed against women. That also you can see. If a woman is upright enough to criticize the some policies of some governmental agency or some organization with respect to women-based issues, and she makes it clear. Suppose she happens to be a celebrity also, there is no amount of there will not be any limit for the amount of hate speech that is published against her over the internet. And many such hate speeches are gaining the attention of millions of people also. So hate speech is an offense. Now, public shaming, or rather internet shaming, is another aspect. You will be targeting a particular group, a particular individual, especially a woman, especially a woman, to have some vulnerable news against her published, or make some false attributions to her, so that she be shamed in the public. So this happens. So this is public shaming, and then what? There is intimidation or threats that happens in the cyber world. And the problem is that the point that I want to press now is that in all the categories, in all the six categories, target in many cases, mostly in 80% of cases, is woman. So such uh, such a situation arises all over the world, such a situation exists all over the world, and still our lawmakers are rather loath in making a faster decision. We need to take decisions which are gender friendly. If offenses are being defined and at least punishments are being prescribed, then higher punishment should be there if the woman should be, if the victim should be a woman, because a woman is made to suffer an offense simply because she happens to be a woman. That is it. And cyber violence against the women and girls. This is the new topic which we want to think how it will be like. It is almost anonymous. It is non-confrontational form of VAWG. If it is violence against a girl and woman, uh, that is happening offline, it is it's perceivable to anybody. It cannot remain anonymous. At least you will hear a woman crying. This aspect, this is strictly interpersonal, but the consequences are very high than even when compared to the physical form of WAG. The cyber WAG is very high. The consequences of cyber WAG is very high also. So it remains to be anonymous and non-confrontational. And the national NCRB data, National Crime Records Bureau of data, shows that around 6,030 cyber crimes were registered by women in the year 2018. And in 2017, it was 4242. This was a number. So you need not be carried away by the lesser number providing. And what happened in 2019, 2020, 2021 is that no data is available in the NCRB. You may go into and check. It's not available there. So they stopped. Actually, I think they stopped taking the data. Well, this sort of it is not because the cyber crimes registered by women, it doesn't happen. It happens quite a lot. Out of 10 offenses that is being committed, at least one or two may be reporting. So the reporting percent has to go high. This is a concept. And there is alarming sort of backlash being received by women and girls when reporting cyber crimes, which you know. Suppose you go to a police station complaining of a cyber violence against you, you will be made to answer many unnecessary questions being put by such officers. So this happens quite a lot in India. And Section 66A, coming to the Section 66, you may be wondering why I did not mention Section 66A. That is obviously because of Shreya Singhal versus Union of India. That case, and we will look into that case. What was actually happening in that case? It was taking within its protected speech and the speech that was innocent in nature. So Section 66A was framed in such a manner that this was not an exception. First, first thing. Secondly, no part of Section 66A had been severable, and therefore the provision was made unconstitutional as such. And Section 66A creates offense which was vague and overbroad. That offense had been vague and overbroad. It was not defined properly. You should have defined it properly. So this is the reason why it was held unconstitutional under Article 19A and not saved by Article 19.2. Why it was not saved by Article 19.2? Why? It didn't form any reasonable restriction. So the nexus, it didn't have a reasonable nexus to the object sought to be achieved by the legislation. So that is why it was struck down as a whole. In Shreya Singhal, the Honorable Supreme Court has never said that this is not an offense. It still continues to be an offense, but the offense was declared in such a way that it was too broad, overbroad, and it was overbroad and it was vague. So for these two reasons, it was done. Now we will come. Still, there is scope for a legislation which is against cyber VAWG and When that offense is being defined, the legislators have to be very careful that it should not be vague and overbroad. First thing. Secondly, it should not be harming protected speech and speech that was innocent in nature. So innocent speech, especially the speech, stand-up comedian speeches, if it doesn't amount to hate speech, there is a very subtle distinction between a good humor and a bad hate speech, which is perceivable to all. So when making a definition, it should not be overbroad. Also, how come the definition should come? There is obviously a need for a legislation against cyber violence against women and girls. It is cyber WAG. Uh, Threats of sexual and physical violence, first category. This is how I would perceive the new legislation would be. There should be threats of sexual and physical violence. This is one category. And secondly, sexist, misogynistic, discriminatory, and prejudicial comments. How come it is sexist, misogynistic, indiscriminatory, and prejudicial comments? You just go into the Instagram, go into the Facebook account of some celebrity who is upright enough to criticize the government. You will find how the sexist, misogynistic, discriminatory, and prejudicial comments do come from people that may not have any bearing with the subject that she has spoken of. And that may not be of the nature of having a discourse with her. No, this would be focusing on some part of her body or some character that she played years back, and she may be abused like anything. So first thing, sexist, misogynistic, discriminatory, and prejudicial comments. It should be communicated to the women and girls via ICT, information and communication technology tools. So it may be computer, maybe it may be done online, or even it can be done through an SMS, short mail service. So all these happens or can happen. The only thing is that it should be happening in the world of the ICT. It should create an we can there is another aspect also. It can create a hostile environment for the victim online. So for the hostile I mean if hate speech is done against a particular celebrity, a woman celebrity especially, it remains for at least for her, right, to remain, that will be creating a hostile environment against her online, against her in the online. So this is how I personally conceive the new legislation should be like. So we need to focus on one more point also, because there is socio-political barriers still do exist to complain and collect evidence. Do you have any idea? Do you have any reservations on that? Still there exist socio-political barriers, because if you want to fight against a particular attack that happened to you online, you may have to tell your parents, you may have to tell your husband, you may have to tell your children, and these barriers do exist for women more. Sometimes I may also have to share the same thing with my family, but still I'm privileged. Being a man, I am privileged. Being a woman is an underprivilege. You agree it or not, that's not my question. But this happens in India. As I told you earlier, this happens only in India. Well, so therefore there should be, what my point is this, therefore there should be a need for a presumption. A presumption, when the nature of the comments, it should be like this. If the nature of the comments or threats communicated are proved, so a particular wording in the particular language is there. Suppose that can be in English, can be in Marathi, can be in Malayalam, any language, and that particular aspect is proved to have happened in the cyber world. You have produced a screenshot. You have produced a Gmail a Gmail account history. You have produced the mail that has been sent by the other person to you. Necessary proof is there to show that the presumption in this particular comment has been published in the Instagram, published in the Facebook, published in somewhere else, WeChat or somewhere else. In the ICT world, in the ICT scenario, this particular thing has been published. So per se, if that shows that the nature of the comments is misogynistic, sexist, discriminatory, and there is the threat of sexual violence or anything else, anything like that. The particular nature is like that, then the offense should be perceived. The burden of proving otherwise should go to the accused. So this sole level of a presumption is also needed as far as this particular topic is concerned. This is how we make a suggestion. And with that, I think I now come to the end of the presentation.